Good day everyone and welcome to the KVV Training Center. Today we will be looking at the various types of marriages in South African law. Did you know that there are 6 types of marriages in terms of which you can be legally married in terms of South African law? Important to note that all of these marriages are valid marriages. It's just in terms of which law it is recognized as a valid marriage that one needs to look at. It does not matter which one of the types it is, the marriage will always either be in or out of community of property. Let's look at the various types of marriages. The first type of marriage is that of in community of property. This marriage derives from the common law, but was codified in law in 1961 by virtue of the Marriages Act. Once you get married in community of property, you will be issued with a marriage certificate by Home Affairs as proof of the valid marriage. So what does it mean to be married in community of property? It basically means that there is one estate as from the date of marriage. When we speak about an estate, we speak about all the assets and liabilities of both parties, which is joint as from the date of marriage. As from the date of marriage, each spouse holds an undivided half share in everything they own. This basically means that the one car is not the one spouse's and the other car the other spouse's. Both spouses own half of each car. This is also applicable to the debts of the estate. So if one party takes out a credit card, for instance, the debt on that credit card is both parties' debt and not just the one. Therefore, spouses married in community of property cannot contract on their own. If they want to buy a house or sell a house, both parties must sign the agreement. If they want to take out a loan, both parties must take out the loan and sign the loan agreement with the bank, as both parties will be jointly liable for the debt owed to the bank. The second type of marriage is that out of community of property. When you get married out of community of property, you can choose to do so with or without the accrual. If you get married without the accrual, it's out and out of community of property. What's yours is yours and what's mine is mine. If you get married with the accrual, it means that whatever is accrued between the spouses after the date of marriage will be divided in two between the spouses. However, it doesn't matter if you get married with or without the accrual. The fact that you are married out of community of property still provides protection against third parties. In other words, the two parties are not liable for each other's debts. So if, for instance, the husband starts a business and the business goes bankrupt, only the husband's estate will be sequestrated and not that of the wife. Out of community of property came about with the Matrimonial Property Act of 1984. It's important to note, to be married out of community of property, the spouses need to sign an antenuptial contract before the date of marriage, and this contract must be registered in the deeds office within 3 months from date of execution. The antenuptial contract is signed in front of a notary who will sign the document and will ensure that the document is lodged and registered in the deeds office. If an antenuptial contract is signed after the date of marriage, it will not be recognized and the marriage will still be in community of property. Spouses that are married in community of property that want to change their marriage to out of community of property can do so, but only by virtue of a court order that is issued by the High Court. So the spouses will have to apply to the High Court for permission to change their matrimonial property system. Spouses married out of community of property will still have a marriage certificate issued by Home Affairs. So your proof of being married out of community of property is both your marriage certificate and your antenuptial contract that was signed and executed before the date of marriage. The third type of marriage that we need to look at is a marriage in terms of the laws of a foreign country. What is important here is that the law states that a marriage is governed by the country of the husband's domicile at the date of marriage. Spouses will therefore be married in terms of the laws of the husband's domicile country. It does not matter where the marriage took place. If, for instance, the husband was domiciled in Britain, but the marriage took place in South Africa, then to see if the marriage is legal, we'll have to look at the legal requirements for a valid marriage in South Africa. But the matrimonial property system will be governed by the laws of Britain, as the husband was domiciled there at the date of marriage. If a spouse is married in terms of the laws of a foreign country, then that spouse can still act on their own. So they can buy or sell on their own, but they will have to have the consent of the spouse if they are burdening the estate with a liability or if they are disposing of an asset. In other words, if, for instance, in our example, the property is registered in the name of the husband who was domiciled in Britain at the date of the marriage, and he wants to sell the property, he will be the only seller in the documents. He will sign the contract on his own, but he will have to be assisted by the spouse. In other words, the spouse will have to give consent to the sale of the property as he is disposing of an asset that the spouse may have an interest in terms of the matrimonial property law of the foreign country. If he wants to buy a property and he buys it in cash, he can do so on his own because he's adding an asset to the estate and therefore does not need the spouse's consent. However, if he now registers a bond, then again the spouse must consent as he is now burdening the estate with a liability. Now we need to look at customary marriages. The definition of a customary marriage is as follows. A marriage concluded in terms of customary law. And customary law is defined as the customs and usages traditionally observed among the indigenous people of South Africa. What's important to note here is that customary marriages used to not be recognized as valid marriages in terms of South African law. However, this position has now changed. Since the inception of the Recognition of Customary Marriages Act of 1998, customary marriages are recognized as valid marriages in terms of South African law as long as certain requirements have been met. This act came into operation on the 15th of November 2000. In terms of Section 6 of the Act, a wife of a customary marriage has, on the basis of equality with her husband and subject to the matrimonial property system governing the marriage, full status and capacity, including the capacity to acquire assets and to dispose thereof. This is an important change that came about with the Customary Marriages Act, as it gives spouses, and specifically the wife, the rights that her husband also had in terms of the previous disposition. So what are the requirements for a valid marriage in terms of the Customary Marriages Act? The Act says that the marriage must be negotiated, entered into, or celebrated in accordance with customary law. Customary law is not defined here by the Act. The reason for this is that the customs of a Zulu couple, a Xhosa couple, a Sotho couple, etc. will differ. The important thing is that the marriage must be negotiated in terms of the specific customs of the couple. Some customs require the lobola to be actually paid before the marriage will be regarded as a legal and valid marriage. Other customs only require the lobola to be negotiated before the marriage will be legal. Regarding the entering into and celebration of the marriage, whatever the custom depicts must also happen. Some customs require an official handing over of the bride ceremony. As long as the marriage is celebrated or entered into in terms of the customs that the couple adhere to, that marriage will be regarded as a valid marriage. Other requirements are that the spouses must be above the age of 18 years and must have consented to the marriage. In other words, the parents of the spouses cannot decide on their behalf that they must get married. They must consent themselves. There must be no existing civil marriage or union that is entered into between the spouses or other spouses. The parties must be South African citizens, so therefore a marriage of a husband or a wife that is not a South African citizen, a Zimbabwean citizen, a Namibian citizen, a British citizen, will not be regarded as a customary marriage in terms of South African customary law. After the 15th of November 2000, when the Act came in, the Act says that the prospective marriage must be registered by the Department of Home Affairs within 3 months after marriage. However, and here is the important point, registration is not a requirement for a valid marriage. If the marriage is not registered, it does not make the marriage invalid. So as long as the marriage have been negotiated, entered into, or celebrated in terms of the customary law, and all the other requirements have been met, then the marriage is a valid marriage, regardless of the fact that the marriage is not registered by Home Affairs. Now the question remains, if we do not have a marriage certificate, how can we prove the existence of the marriage? And the only answer to this is an affidavit signed by both spouses confirming the fact that they are either married or not yet married in terms of customary law. Now let's look at the consequences prior to the 15th of November 2000. So if the marriage was entered into prior to the commencement of the Act, then a monogamous marriage will be regarded as married in community of property. However, a polygamous marriage will still be subject to customary law, as was the position before the Act came in. The consequences of a marriage after the 15th of November 2000 will be as follows. A monogamous marriage will be regarded as married in community of property, unless the spouse has signed an antenuptial contract, in which event the marriage will be out of community of property. A polygamous marriage, however, is different. Although there is no restriction on the number of customary marriages that a man may have, no further customary marriage may be entered into without a court order regulating the future matrimonial property system of his marriage. In other words, if a man wants to take a second, a third, or a fourth wife, etc., then every time before he marries this person, he needs to approach the court and get a court order to confirm the matrimonial property system for the future marriage. Couples married in terms of Muslim or Hindu law will not be regarded as being legally married in terms of South African law. These marriages are governed by faith and not by law. Therefore, spouses to such a marriage will have the same rights as an unmarried person when it comes to the buying or selling of property, unless they are married in terms of the Marriages Act. Some of the imams or alims in terms of Muslim law are registered as marriage officers and can perform valid marriages, in which event the parties will be issued with a marriage certificate in terms of the Marriages Act. The last way of being legally married in terms of South African law is by the Civil Union Act. This act came in 2006 and is the act that provides for same-sex marriages. However, it's not just same-sex couples that can get married in terms of the Civil Union Act. In terms of the Civil Union Act, you also have a choice between a marriage and a civil union, and this choice will be noted on your marriage certificate. In terms of the Civil Union Act, you may only have one partner, and you may not yet be married in terms of any other law before getting married in terms of the Civil Union Act. You will still be issued with a marriage certificate issued by Home Affairs, and on the certificate it will note that your marriage is in terms of the Civil Union Act and not in terms of the Marriages Act. The marriage will still be in community of property unless an antenuptial contract is signed and registered. Interesting to note is that the marriage officer may refuse to perform a civil union marriage on grounds of conscience, religion, or belief. These are the 6 ways in terms of which one can be married legally in terms of South African law. If you have any further questions or queries, please do not hesitate to contact us through our website or on our telephone number as provided. Thank you. Goodbye.